In February 2017, Oakland County deputies executed a search warrant at the Michigan home of Joseph Sheely, a tenured business professor at Oakland University. Police acted on anonymous tips alleging that Sheely hosted parties involving underage drinking and drug use. During the search, officers found ketamine and several unloaded firearms. 4 young adults were present, including a student named Jacob Spencer. As a result, Sheely was charged with multiple felonies, including possession of ketamine, maintaining a drug house, and firearm-related offenses. Prosecutors also alleged that Sheely had supplied ketamine to Spencer. The case went to trial in early 2018 before Oakland County Circuit Judge Cheryl Matthews.
Mr. Spencer, you have been around people who have used narcotics, haven't you?
Yes.
And you've seen people who, in your experience, appear to be high, haven't you?
Yes.
Who appear to be under the influence of some kind of a drug or affected by some kind of a narcotic, haven't you?
Yes.
Can you look the jury in the eye and tell me whether or not you've taken any narcotics today? Prescription pills, anything of that sort? Xanax, opiates?
Yes, I have taken prescription pills today.
When did you last take a prescription pill today?
This morning.
What time?
I'd say around 9 o'clock.
And what medication did you take this morning around 9 o'clock before you came to court?
I took Vyvanse.
Vyvanse. Vyvanse is an amphetamine?
Yes, I'm prescribed.
Vyvanse is for ADHD?
Yes.
The behavior, the way that you're communicating, and I'm going to speak to you, try to speak softly and have a dialogue with you, okay?
Okay.
The way that you're communicating now, isn't this the way that you've seen people communicate in your own personal life who appear to be high or under the influence?
Judge, I'm going to object to that.
What's the...
Judge, he can ask him if he's high or under the influence, but
I'm not to ask
he's
him.
asking him to evaluate his...
I don't understand the question.
Okay.
I don't understand how I could look at myself from a third-person view.
So well, first of all, so the prosecutor objected, Your Honor.
Say the question again, I didn't understand.
Yeah, sure. The way that you're communicating now, I mean, can you hear, I'll withdraw and I'll ask it differently. Can you?
Are you fine right now?
No, I'm not.
Okay.
This is the way that you normally communicate?
I don't normally communicate from a stand in circuit court in a case involving an older man that threw parties with underage people providing drugs. I'm nervous. If you're accusing me of being drugs, then you're doing a very bad job as an attorney.
Okay.
You should be asking questions that are actually going to help your client.
Okay, next question.
I appreciate that.
And now I'm angry and I'm going to tremble my voice even more, not because I'm on drugs, but because I'm nervous.
Okay.
And you're intimidating. That's what you do.
Okay,
And it's not going to work.
Okay, just answer the questions and then.
That's my answer.
Okay, just answer his questions and we'll get you out of here, okay? All right, go ahead,
Okay.
sir.
Thank you, Your Honor. Today, you testified a few moments ago to the jury in response to Ms. Hand's questions that Joe has provided you with ketamine on prior occasions at his house.
Correct.
You said it was almost, I think I wrote down, said almost every time you were there. You remember that?
Yes.
At the preliminary examination, that was when you testified before in district court. Do you remember that?
Yes.
And you took an oath at that time, is that right?
Yes.
And at the time that was closer in time to the events of February 15th, true?
Yes.
And you told that time you were asked this question, and this was your answer on page 62. Approximately how many times had you ingested ketamine that the defendant gave you at his house? Your answer, it was one time. It was that night. Wasn't that your answer under oath at the preliminary examination?
Yes, it was.
Today you've told the jury something different, haven't you?
Yes, I have.
So 2 times under oath, you've given 2 different answers. True?
True.
Both of those pieces of testimony can't be true, right?
Jacob Spencer testified for the prosecution under a grant of use immunity, meaning his testimony could not be used to charge him with crimes based solely on what he said in court. During cross-examination, defense attorney Neil Rockand challenged Spencer's credibility by pointing out inconsistent sworn statements. Spencer had previously testified under oath that he received ketamine only once, but later claimed it happened multiple times. Under Michigan law, prior sworn statements that conflict with trial testimony can be used to impeach a witness. When Spencer admitted that he had lied previously, including about cocaine use, the defense argued that his testimony was unreliable and motivated by self-interest rather than truth. Although Spencer's admission appeared to meet the legal definition of perjury, his immunity agreement likely protected him from prosecution.
I know you said to only keep this yes and no, but I'd like to explain that this isn't about the amount of times that I did ketamine at Joe's house. This is about, it goes beyond that. Like I've stated multiple times, I was very inebriated every time that I was at his house. I may have even been given ketamine without knowing it.
You've never told the police before in response to any question. Let me finish my question.
Look.
You'll get every opportunity, Mr. Spencer. I'm keeping my voice very calm. I'm going to give you every opportunity to talk as much as you'd like. But you've never before today in front of this jury made an allegation that somebody gave you ketamine without your knowledge. Isn't that true?
Can you please rephrase the question?
Yes. Until just now, you've never told the police or accused in a formal setting, in this case, Joe, of having given you ketamine without your knowledge, right?
Correct.
That's something new that you just told the jury now.
Well, maybe it was something that I didn't consider when I first stated that I only did it one time.
I'm sorry. I'm asking you, I'm moving on to another subject. You're here testifying in court. You understand that, correct?
Mm-hmm.
Yes?
Yes.
You've just made another allegation against Mr. Shield that he drugged you with ketamine without your knowledge. Isn't that true? That's what you just told the jury.
Yes, it is.
Never told that to any police officer formally, nor did you testify to that previously in this case.
I may have mentioned it before. I'm not sure. There were so many times that I talked to detectives.
You just told the jury a second ago that it didn't dawn on you to think about that. Now you're saying that you actually may have said something about that. Those are two different things, aren't they?
Do you want me to go back and explain myself?
No, I'm asking you a specific question, Mr. Spencer.
Yes.
So your testimony today includes a new allegation against Mr. Shield that you were somehow drugged without your knowledge.
I'm not saying that. I'm saying that it's a possibility. I'm not saying that that specifically happened. I'm saying it's a possibility, as in there's no way anybody's ever going to be able to know that. I don't even know that myself. I'm just saying possibly, and maybe I considered that when I just said that I took ketamine multiple times at his house. Maybe I considered that it's a possibility, but there's no way I'm ever going to know if it actually happened.
Wait a minute.
That's what I'm implying.
Under oath,
I'm not alleging him of anything.
Under oath, the prosecutor asked you on direct examination whether Mr. Shield, whether it had provided you with ketamine prior to, at the time she went to his house. She asked you that. It was a very simple question. Do you remember it? Do you remember the question and answer a few moments ago?
Yes.
And you said yes. And you said, almost every time I was there.
Yes.
And you're saying that when you told the jury that under oath, that you were thinking to yourself that maybe it was given to me without my knowledge? Is that your explanation for that testimony under oath?
Yes, it is.
That make any sense to you? That you would answer a question directly that he gave you drugs in the past, gave you ketamine in the past, but now when I'm questioning you, it's, well, maybe I was thinking of, maybe I was drugged and didn't know it. That's why I answered it that way. Is that really the explanation you want the jury to accept?
I don't know how else you would want me to explain this. I would appreciate if you could move on to the next question.
I'm sorry? You want me to move on to the next question?
Yes.
The questions I'm asking are, Mr. Spencer, pointing out from contradictions in your testimony. Do you understand that? So I appreciate you would like me to move on, but I'm sure you can appreciate that the judge will ultimately tell me when I have to move on. You understand that too, right?
Correct.
Okay. You want me to move on because it makes you uncomfortable to have to getting caught in what is untruthful testimony.
Well, there's a lot of these really small discrepancies, like how many times did you do this? How many times did blah, 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 that like, I didn't just like, this isn't like a test that I studied for. This isn't college. This isn't something that I think is like a huge deal. So when you guys throw all these questions at me and then throw it on the record, it's not something that's like constantly running through my mind every day. And I'm remembering all these little tiny little details and splitting hairs about it.
That's what I'm doing? You think I'm splitting hairs? I'm questioning you about the truthfulness of your testimony and contradictions, and you're telling the jury that that's splitting hairs. Is that what you're
I'm
characterizing?
giving my time trying to answer all of these questions to the best of my ability.
We'll get to the reasons why you're here later, okay? Do you understand? But I'm still going to put these questions to you. Is that okay with you, Mr. Spencer?
Yeah, ask another question.
Thank you.
Yeah.
You testified today that on February 15th, that you drank alcohol. That's what your testimony was under oath just a few moments ago to the jury, right?
Correct.
You were asked this question at the preliminary examination, page 62, lines 18 to 19. Did you drink alcohol that night? Your answer was no, I did not. Correct?
Correct.
Again, your testimony today is different than it was at the preliminary examination when you testified under oath there, right?
Correct.
You told the jury a few moments ago in response to Ms. Hand's questions that she asked you about nitrous oxide. Remember those?
Yes.
She asked you about whether or not you asked you about cocaine being provided to you at Joe's house. Do you remember that?
Yes.
You said that Joe had provided you with cocaine. You said that that was your testimony on direct examination. Do you remember that?
Yes.
That's not true, is it?
Pardon me?
Joe never gave you cocaine, and you didn't do cocaine at Joe's house. That's a lie, right?
Please, can you please rephrase the question?
The question was confusing to you?
No, can you just...
Yes. You testified today that Joe gave you cocaine and you used cocaine at Joe's house previously. That's what you testified to today. You've
Yes.
acknowledged that. I'm putting to you that that is not true. That is a lie, correct?
That is not a lie. I did use cocaine at Joe's house.
Okay. On page 61, lines 15 through 17, at the preliminary examination where you testified closer in time, the question was put to you, did you partake of the nitrous oxide or the cocaine? Your answer was no, but I've heard and seen it at his house on occasions. Wasn't that your answer under oath then?
That may have been. I don't know. I
Is
haven't...
that both of those can't be true, Mr. Spencer.
Okay, so that was your answer at the preliminary exam, correct?
Yes.
Okay, that's the next question.
Both of those can't be true. What you testified to today to the jury and what you testified to under oath at the preliminary examination, right?
Yes.
So one of them is a lie.
I was lying about not using them.
You were
Because I felt
lying at the
guilty
preliminary
because-
examination.
I felt guilty because my dad was in the room.
At the preliminary examination, you were under, let's just, so the jury understands that. You took an oath before you testified in the preliminary examination. Is that correct?
I didn't want my dad to hear that I was using cocaine.
You took an oath to testify to the truth at the preliminary examination in district court, right?
Correct.
You raised your right hand just as you did today.
Correct.
You looked, there was a judge there named Judge Nancy Karniak, right?
Correct.
You looked her right in the eye and answered the question, no. Isn't that true? And you're
Correct.
testifying now is that was a deliberate, intentional lie.
He said yes.
Isn't that perjury?
Well, he's,
Yes, it is.
Okay, I'll rephrase it. You recognize that when you're under oath, you face the penalty of perjury, don't you?
Yes.
You understand deliberately and intentionally lying under oath for any reason is perjury. Do you understand that?
Yes, I do.
So you concede that you committed perjury from your own perspective. By your own words, you committed perjury at the preliminary examination.
Yes.
When the police entered the house that night, you were in possession of drugs, right?
Yes, I was.
And tell us again what drugs you were in possession of.
Xanax.
Xanax. How many Xanax pills were you in possession of?
2.
And you did not have a prescription for those pills, isn't that true?
That's true.
You understood at the time you were possessing that it was a crime to possess them, isn't that right?
Yes, I did understand that.
You understood that it was a serious crime,
Yes.
and you understood that it was a felony.
Yes, I did understand that.
So you knew that when the police entered into the house that night that you were committing a felony.
Yes.
You knew that you were committing multiple felonies if you count the number of pills you possessed. Isn't that true?
Objection, Judge. It calls for a legal conclusion.
I withdraw it.
It's true.
I withdraw it. It's fine. I withdraw it. I'm asking questions very politely, Your Honor.
He is asking questions.
But you know that's not true.
Well, I don't know. I resent that because I'm not suggesting that I know that that's not true, and I don't like to suggest. You know me. I'm not suggesting anything.
You suggested to the jury that if you have 2...
I'm asking a question. You know what? Then I'm asking a question, and if I'm wrong about that, then I'm wrong about that. And I certainly will withdraw that.
All right,
So-
next question.
So I will withdraw that.
Mr. Rockhind asks Mr. Spencer whether he knew that he was committing 2 separate felonies by possessing 2 Xanax pills, prompting an objection from the prosecutor, and Judge Matthews sustains the objection, explaining that Mr. Rockhind's question incorrectly suggested to the jury that a person can be charged with 2 counts of possession merely for having 2 pills. Alprazolam, the active ingredient in Xanax, is classified as a Schedule IV controlled substance, and unlawful possession is governed by Section 333.7403 of the Michigan compiled laws, which makes it a felony to knowingly or intentionally possess a Schedule IV substance without a valid prescription. The statute criminalizes the act of possession, not the number of units possessed. Thus, possessing 2 Xanax tablets at the same time constitutes a single offense of possession rather than 2 separate felonies. Accordingly, Judge Matthews sustained the objection because Mr. Rockhind's question implied to the jury that a person could be charged with multiple felony counts for possessing multiple pills of the same substance at the same moment, which is not an accurate statement of Michigan law.
And when you agreed to testify at the preliminary examination, it was your belief that if you cooperated and testified that you weren't going to be charged in the case. Isn't that true?
Yes, that's true.
And despite whatever it is that you did, you believed at that time that you'll end up with no criminal prosecution and no criminal record. Isn't that true?
That's what I was told.
And who told you that?
That.
Ms. Hand, seated to my right and to your left. And despite whatever it is that you did, you'll end up with no criminal prosecution and no criminal record. That's what you're testifying to. That's what you just testified
granted
to.
use immunity, I believe the term is.
And you just testified a moment ago that you were told that you'd end up with no criminal prosecution and no criminal record, right?
Well, no prosecution for the possession of prescription pills.
So that's more than use immunity. Use immunity means, doesn't it, as far as you know, that you just get to, your words can't be used against you. But you're telling us that you actually have an understanding that you're not going to be prosecuted at all for your felonies, right?
Correct.
Isn't that in part why you're in here saying the things you are about Joe, so that you avoid a felony prosecution and felony conviction yourself?
Correct.
You're a young person. You're 20 years old, you said? Yes?
Yes.
You want to have a career and a future, right?
Yes.
You have a lot to lose. Would you agree with that?
Yes.
And your participation or involvement in some kind of crime could interfere with that. Would you agree with that?
Yes.
You understood that based upon what you were being told, that if you talked about Joe, you'd be able to avoid being in trouble, right?
Yes.
1 year ago, well, so not 1 year ago, this was back in February 15th of 2017 is when this search of Joe's house took place, correct?
Correct.
Today is January 18th or 19th. 19th, Your Honor? 19th. Thank you. In that time, you have not been charged, have you?
No, I have not.
And there are things that you did go down and talk to the police on March 1st of last year, correct?
Yeah, it was around that time.
You got a record deal the day before that, didn't you?
Pardon me?
Didn't you get a record deal? Did you get a...
That makes it sound like he's a singer.
No. Well, aren't you a performer, a DJ?
What does this have to do with?
We'll let the jury sort that
Are you talking
out.
about this case?
Yes, I am. Yes,
I don't
February
think this
28th of 2017, the day before you went down to the police department to talk about Joe, didn't you get a record deal?
Oh, you do mean like singing.
I think a DJ.
Oh, I thought you meant, okay, all right.
Didn't you get a record deal? Didn't you just get a contract by a company that signed you? Didn't you, something you were proud of?
I'm confused as to why you're asking me this and
Well,
why you're
let's-
asking me to disclose personal information.
He's trying to ask you if you have a lot to lose.
So on February 28th, before you went, you talked to the police, you got a record deal. You got a professional
Yeah,
music contract. That was something you coveted, that you were proud of.
yeah,
You understood that a criminal case and a criminal prosecution could interfere with that, didn't you?
yes,
So the very next day, March 1st, that's when you went down and you talked to the police at the police station about Joe, right?
yes.
One key courtroom moment involved a legal objection during cross-examination about Spencer's possession of Xanax. The defense suggested that possessing 2 pills meant committing multiple felonies. Judge Matthews correctly sustained the objection, clarifying that under Michigan law, possession of a controlled substance is charged as one offense, regardless of the number of pills. In January 2018, the jury returned mixed verdicts. Joseph Sheely was acquitted of the charge that he delivered ketamine to Spencer, but convicted of possession of ketamine, maintaining a drug house, and possessing firearms during that offense. He was sentenced to 3 to 4 years in prison and later ordered deported to Canada. This case shows how witness credibility can determine outcomes. The jury's rejection of the delivery charge suggests that doubts about Spencer's testimony played a significant role, proving that cross-examination remains one of the most powerful tools in the American justice system. Thank you for watching Court of Audits. Subscribe for more clear, fact-based courtroom analysis. Until next time, stay curious and stay informed.